In a courtroom filled with tension, lives hang in balance. Defendants plead, lawyers argue, and judges decide fate in silence. From broken promises to second chances, this is the battle where justice never sleeps.
So all discovery is complete on all of these matters?
To our knowledge,
Yes,
Your Honor, yes.
All right. And would the people have their witnesses available on the 13th?
We can try for that date, Your Honor.
All right. Preliminary examination in all of these matters will be set for November 13th, 2025, 10 a.m. That's before Judge Barr on all matters.
Okay.
All right.
Thank you, Your Honor.
Bond will continue. Is that it for Mr. Davis? So I won't see him again?
That is correct.
All right. Take care.
In a courtroom charged with emotion, defendants stand one by one before the judge. Each story, a struggle for freedom. Each word, a gamble with fate.
Executor's call for you.
Morning. Morning, Your Honor. Michael
Yes.
Kennedy, Assistant Public Defender, on behalf of Mr.
Simpson.
Myers.
All right. Your name, sir?
State your name.
Okay. He doesn't want to state his. Are you Mr. Meyer?
He's stating his name.
Okay. Thank you. All right. What are we doing?
Your Honor, I have to ask for an adjournment. I went to see Mr. Myers. He was not available to be visited when I went to see him. I'll try again. Ms. Anderson from my office asked me to let you know there's a new case that's on the arraignment list today. I don't know if the court wanted to arraign.
Today?
Yeah. He's on the 1:30 docket. It looks like it's a...
Mr. Davis appears first. Calm faces hide anxious hearts. Discovery is done, and his fate moves to November 13th, a date that could redefine his future.
And we'll continue. Can you let the
You go to court on the
magistrate
13th. They got
know
adjourned.
to put this on the 13th? I think that's the
I'll
date
let
they planned anyway. Thank you, sir.
I'll come visit you, Mr. Myers.
Well, I'll tell you what he said.
Pardon? Okay, he's got it. Court does call the case. People versus Kyle Wilson.
Chairman, Dadish, on behalf of Mr. Wilson, who is approaching.
Kyle Wilson. You're requesting an adjournment. Can counsel approach, please?
Next, Brandon Myers. Silence says more than words. The judge sees hesitation, but justice moves forward. No escape from the ticking clock of the law.
With his sister, one of his other children, he usually stays with throughout the day, so he'd like to be able to get released so he can go back and take care of his children and be able to provide for them. He also has let me know that he has somewhere else to go. He has either he can either go to his sister's house or to one of his children's mother's addresses. Neither of those are in Washtenaw. He's okay getting released on a GPS tether. He has no reason to come back to Washtenaw except for this case. The house that he could go to, his job is in Southfield. And then I believe your sister's address is
Oak Park.
Oak Park. And then the child's mother is in Westland. So really far away from here. Well, not really far away. We can do a hot zone tether with a GPS zone that's quite big. He will not violate. He just wants to be able to get back to his job so he doesn't lose it and be able to provide for him.
Kyle Wilson takes the stand. A father of 4, pleading for release, not for himself, but for the children waiting at home, wondering when dad will return.
On their website for that case, a bench warrant had been issued at this time. In this case,
Hold on. I just want to make sure I understand it. At the time, the alleged time of this offense, he's on probation.
for a DV, GBH, and DV charge that he pled to.
All right. And there's a bench warrant that's being issued. Was that bench warrant issued in response, if you know, to these charges, or was there something else where he was non-compliant?
I believe it's these. I don't know exactly. It just says order for bench warrant issued expedited on 10/22 of this year.
If I may, Your Honor.
On 10/22. So that was probably, Go ahead, Councilor.
But behind the plea lies a shadow, probation, old charges, and a bench warrant hanging over him like a storm cloud ready to break.
He knows about that. He's complying with that. He was about to be discharged November. He had done everything he's supposed to do. He was ordered to do, anger management classes, and he completed what he was supposed to complete and is still doing more classes on his own, whim. He felt like it was helping him. And again, he was doing very well. He was about to be discharged. He was waiting on the discharge letters.
He was doing everything he was supposed to do except have contact with the police and potentially commit other offenses.
Yes,
Right?
Your Honor.
That's what you meant to say.
That's what I meant.
Go ahead.
He was about to think about other strangulation and domestic violence case, and in this case, the victim is extremely terrified of him. She reported 2 different strangulation incidents, one that was out of county and one in Washington, and that the defendant had left with her car for an extended period of time and she wanted it back to run errands. He became extremely upset, told her, "Stop telling me what to do."
As the defense speaks of change and progress, the prosecution paints a darker picture: violence, fear, and a victim too terrified to sleep at night.
Her throat, one over her mouth. While she's still on top of the child, strangled her. And when law enforcement arrives, he refuses to come out of the house. Officers had to kick in the door, which it was stopped partially by the deadbolt. They eventually were able to kick it open fully and arrest him, at which point he was still tensing up, pulling away. And during these assaults, he had also told the victim, "I wouldn't kill you because nobody's worth me going to jail for life. I've had someone else do it." So I have extreme concerns given that a new strangulation case occurs while he's about to go to probation for a strangulation case that he pled to. And he's also resisting law enforcement officers at the scene of this event. So I have concerns for the victims, the community, law enforcement, and the high lethality factors in this case. So I would reject any modification of bond at this time.
I just add, Your Honor, that these are just allegations at this point.
Yeah, but I'm presuming
The judge listens in silence. Evidence, emotion, and justice collide. And in that moment, mercy feels like a dangerous luxury.
And while there are allegations, certainly there becomes a problem if all of this is going on and there's a lack of cooperation with police officers.
I don't, again, want to speak to the exact details of the case, but from my review of the video, Your Honor, again, I don't want to get into the details, but it's definitely questionable whether he was resisting arrest or not in my review of the videos.
In looking at this, frankly, his bond currently is set at $75,000 cash surety. I'm going to deny the request for a reduction. I do find the defendant, having been on probation and then allegedly committing these offenses, to be a danger and risk to the public. Quite frankly, and I did not take their indication of what they had requested as a request to raise the bond in this case. I will decline to do so, although I think that the bond in this court.
With the final word, the gavel falls. Bond denied. The courtroom exhales. Another life paused in the endless rhythm of justice.